Good to be with everyone on today's webinar. Once again, we have another timely and hopefully informative program for you all. Before I turn it over to my colleague, Nyla, I wanted to talk a little bit about where we stand right now in some of the metrics with COVID. I took a look at the Johns Hopkins website this morning. For those of you who don't know, that's commonly a source for a lot of the information that you see conveyed in the media, but it's pretty user-friendly. I encourage you to check it out. There's a lot of data there. This is data that I pulled for New York, and I thought you might be interested in. It tracks with, I think, what we're seeing and hearing by and large through the media and different social media outlets. But I did want to convey it. Obviously, here on the top chart, what this is the 7-day average of positive cases, or the average number of daily cases in New York. So looking at a 7-day average, obviously we see a very significant spike here at the tail end that we're all experiencing and that the media, of course, is reporting on frequently. The data below it and the graph below it reflects the 7-day average for the number of deaths. And of course, we have seen this stay fairly steady. There has been an uptick at the tail end of the graph, as you'll see here. But I think that in a takeaway when comparing these two charts for me is, although we've seen this really a very significant increase in the number of daily cases in terms of the 7-day average, we haven't seen a comparable increase in spike in the number of deaths. So of course, that's very good news that we're not seeing a proportional increase there as well. Moving on to the next slide, a couple more sets of data that I wanted to just reference for you. The number of hospitalizations, again, this is a 7-day average here in New York. We see starting in the fall a significant increase and spike, which again is consistent with what we're seeing reported and I think experiencing in our communities. I would just mention here that it does seem to be leveling off some of the other data that I've reviewed, including some data in the city, would suggest that there are some downward trending data right now that are very positive, encouraging. Certainly not out of the woods yet, but some positive developments there. And finally, just on the last chart on the bottom here, what that is the positivity rates that you see in the number of tests that are being conducted for COVID each day. So the fainter data reflected on the graph are the number of tests. So you see we have an increase in the number of tests and a slight bump in the positivity. I think we were, when I checked, around 5% or so right now. But again, you see a somewhat proportional increase in the number of positive tests with the number of tests that are being conducted. And as well here, you see a slight dip at the end, which hopefully is encouraging news and will be followed by more positive, good news. So that's what we're seeing in terms of the trends. I know you have many questions. I'm going to try to cover some of the questions that were asked last time at the end of this webinar. We're going to have a brief visit from my colleague, Adam Masterleo, who's going to talk about his webinar tomorrow, a standalone webinar that's going to be dealing with isolation and quarantine periods and the interplay with paid sick leave in New York. But before we do that, our colleague Nyla Sikander is back with us again. Nyla is going to talk about where things stand with OSHA's Vax or Test, ETS. I know this is an issue that many of our clients and friends of the firms are following. So Nyla, great to have you with us. Thanks for joining.
Thanks, Andy. So welcome back, everyone. In the world of OSHA's ETS, it seems that change is the only constant. If you've sat in on our webinars before, you've probably seen this slide pop up in terms of kind of the trajectory of how OSHA's kind of ETS has traveled through the litigation system from inception to kind of where we are right now. The last time we spoke, I had shared that, well, you know, the Supreme Court has kind of scheduled oral arguments for January 7th, and we were going to await the court's decision. We're still awaiting the court's decision. And our first compliance date for OSHA's ETS has come and gone. It was January 10th, which was yesterday. February 9th is the next compliance date. However, as you can see, things could change in the next couple of days. Next slide, please. So I kind of wanted to talk a little bit about the Supreme Court's oral arguments at their special session on January 7th. The decision is still pending. Again, while it's very hard to kind of sometimes predict how the justices will rule, many of the justices appear to be skeptical of the ETS. Justice Alito, quoting the late Justice Scalia, kind of described OSHA's interpretation as squeezing an elephant into a mouse hole. And interestingly, and this is, I think, the issue at hand, is the justices focused on the major questions doctrine. And to simplify it, usually when a statute is silent or ambiguous, the court defers to the administrative agency's determination. However, when there is a significant political or economic question or issue, then the court kind of has carved out this exception where it says, you know what, we need to kind of take a look at and determine if the agency is operating under authority delegated to it by Congress. So there is kind of an extra layer. So I think based on the questions, that appeared to be one of the major focuses there. The justices focused on if OSHA had, authority to mandate the vaccine that impacts not only the workplace, but all our employees' lives. Chief Justice Roberts actually called it an out in the world issue. The court floated the idea of like a brief administrative stay pending the decision. I know the applicant said, well, you need to please, court, we respectfully request that you stay this ETS prior to January 10th, but the weekend came and went. I refreshed the Supreme Court's website multiple times to check for an update, but nothing yet. On January 10th, the court did release some opinions, but none of it had to do with OSHA's ETS. Solicitor General Prelogar, who actually appeared for OSHA, the Department of Labor and OSHA, disagreed and said, January 10th, it's a deadline, but it doesn't pose a major burden on businesses except for, imposing masking requirements for employers or, states that don't have those requirements. And employers are required to maintain a roster of each employee's vaccination status. So at the most, those could be some of the obligations. Is kind of what she posed in her argument. Now, I have, the court did announce that it will be issuing opinions. It won't be taking the bench, but it will be issuing opinions, one or more opinions on January 13th. That's a Thursday. So it's unclear if that's going to be about OSHA's ETS, but it's a date. It's something for us to kind of look out for. So let's see what happens on Thursday. Something might happen, nothing might happen. I'm hoping that we'll hear something before February 9th, which is kind of when some of the testing requirements come into place. And I know many of you have had questions on how we kind of have to logistically make that work. So next slide, please. So we talked about this. OSHA, the ETS's first compliance deadline is here. And if you've sat in on these webinars, you're already probably set. You've got a policy in place. You've worked on your vaccination roster. You have notices ready. You have a method of kind of making sure that you're removing employees who test positive for COVID. So you're probably in good shape. But if you have been waiting on OSHA's decision, the court's decision, and some employers have choose to do that. If you are doing that, just make sure that you make reasonable, good faith efforts to comply with the requirements. You do need to make sure that you're doing that. I actually, next slide, please. I've shown you this slide before. It has a quick summary of the obligations on your part in terms of things that you're required to do. Take a look at that. Use that as kind of your checklist to kind of jump off and like just get started on some of this stuff if you haven't already. Next slide, please. So meanwhile, while all of this is going on, OSHA has been busy. It's been updating and clarifying and including additional questions on the ETS. And I know we're still kind of getting our head wrapped around policies and what we need to do, but I wanted to kind of highlight these really quickly. The additional questions are very limited types of exceptions, but I figured we'd talk about it. So one of the questions is, what happens if an employer mandates vaccines? So they've decided to go with the option where they're going to mandate vaccines for all the COVID vaccines for all of their employees, but they still have a small number of unvaccinated workers. So OSHA had stated that it will review the employer's good faith efforts to vaccinate the entire workforce. And what they're going to look at is a percentage or the extent of the workforce that is vaccinated and steps that you have taken as an employer to protect unvaccinated workers. And that seems like, oh, yeah, I mean, we can probably prove that. But when OSHA also goes another step further and provides examples, and that's where I think their interpretation of that could be narrower than how many of us could look at it. And one of the examples is where work sites where almost all workers are vaccinated. So approximately 95% of the workers are vaccinated, and anyone who remains unvaccinated has limited to no contact with others. There are also situations where work sites with only a small portion of unvaccinated workers, when those who are unvaccinated have had the first dose, as you can recall, to be fully vaccinated, the criteria for fully vaccination. So if they have received the first dose and are scheduled to receive the final requisite dose in a 2-dose vaccination kind of protocol, then that would be a situation that OSHA will kind of review and accept in terms of your compliance. They also have another explanation, and this is example, and this is to do with new employees who you actually hire into the workforce. So establishments with high employee turnover rates where consistent efforts are made to ensure that new employees are promptly incorporated into the employer's vaccination policy. So you have a revolving door and it's hard to find employees. And when you do, you need to make sure that you're staffed, adequately staffed. In those instances, what are you doing as an employer in terms of making sure that employees comply with your vaccination policy? So those are some of the questions. If this ever pops up, we should talk about this in terms of you should, seek some input from your legal counsel as to how you want to approach if you have a mandatory vaccination policy. How should we kind of work through this small number of unvaccinated workers? That is a question you want to kind of look into it further. Next slide, please. It also clarified questions regarding testing. And I know, I think in the past week, 2 weeks, I've received so many questions on testing requirements. And if OSHA's ETS is not stayed, I think I'm going to have to come back and go through testing requirements with you. That might be just like a whole separate session, Andy. But I wanted to quickly touch on some common questions that I'm asked, and OSHA's kind of provided clarification on. The testing requirements, they talk about like the use of over-the-counter tests and who proctors these tests, and they can be observed by an employer or a licensed telehealth provider. So there has to be someone who proctors over-the-counter tests. An employee cannot self-administer the test and read the test. So I can't purchase a home test, an at-home test, administer it, and then get the results and say, oops, yep, I'm negative, I'm good to go, here's a photo of it. That is a no-no. There's a small exception to this. There are tests that feature digital reporting of dates and time stamps. So there's like a time and date stamp on those tests, and those are not considered self-read. So in those instances, an employer doesn't necessarily have to observe that test. So acceptable documentation of test results when test is observed by an employer. This is another question that I get, and OSHA's talked about that as well. Now, if you are observing this test as an employer, there's kind of two components to it. You kind of have to make sure you have documentation of your observation, and make sure that you've observed not only the administration, but also the test result. And you must preserve these records of test results. So OSHA's talked about you need to document the test result through a written statement. So you make a note. Some employers have decided to come up with a form where they say, this is the date and time observed, the observer, and the results. And this is an example that OSHA's provided, but employers have kind of started creating a form from a logistical perspective. You're not required to do that, but some form of this written statement. A photograph of the test result or a video of the test result, if documented and recorded by the employer at the time the test is conducted or observed. So there is this idea that has been floating around where employers are like, well, I'm just gonna record these employees getting their test, and then I will observe it later. Well, that's not going to work. So OSHA's kind of said, no, you need to, if you're recording that, or you're taking a photograph of the test result or the video of the test result at the time that you're observing it, and you've documented that, that's fine. But you can't necessarily record 20 videos of 20 employees taking the test and then look at it later. So just keep that in mind. An employer that merely obtains an employee's test result information verbally and makes no record of the test would not satisfy the standard. So if you look at the test result and say, oh, yep, it's negative, and you don't have necessarily information to support, you don't have supporting documentation, that would not satisfy the standard. And then the record maintenance requirements cannot be fulfilled if an employee merely shows the employee their documentation of the test result, or the employer simply observes the test result. So again, very similar to the previous example, by seeing the employee's test results after observing the test in person without any documentation. So there's that two-part piece. This just emphasizes, make sure you document your observation and document the test result as well. That kind of completes a complete record if you are doing these at-home, over-the-counter tests. You must preserve records of test results. They are considered, you must preserve that. And we can talk about testing. I will actually go into testing in detail. This is just an overview, but I figured we'd just kind of go over it based on what OSHA is telling us, and then questions that you've been asking of us. Next slide, please. Thank you. So there is also a very limited exception to some employers have prepared vaccination rosters before November 5th, which is the effective date of the ETS. So there were vaccination rosters that were prepared before then. What do we do now? So if in the limited exception where an employee's fully vaccinated status has been documented prior to November 5th, OSHA has carved out an exception in terms of how you can, what is considered acceptable documentation. This is an exception to OSHA has a standard requirement in terms of what are acceptable documentation for verifying vaccination status. This is a limited exception, so do not confuse this with, oh, I can actually do this. You can't, unless you started maintaining your vaccination rosters prior to November 5th to verify an employee's fully vaccinated status. So in this instance, where an employee, say, verbally self-reported their vaccination without providing any form of proof. So now the employee has told you October 31st, I'm fully vaccinated. Such self-reporting is acceptable where you as the employer, you have had the employees provide their vaccination information on a dated form or through an individual email that you retained, or they submitted their vaccination status on an employer portal, so your human resources information system or your intranet or whatever that is that tracks this status. And that was specifically created for employees to provide documentation status. Or you created and retained some other means of documentation. So a spreadsheet documenting oral conversations with employees who confirm their fully vaccinated status. I would recommend that if this is your situation and you're having this issue, have an independent set of eyes. Your legal counsel kind of take a look at this vaccination roster to make sure that you're being compliant with it. And I mean, that's pretty much it in terms of kind of my spiel today and my status update with regard to the OSHA ATS. We will keep you posted. I'm sure things are going to pop up soon. Things are going to change. OSHA continues to revise, update, and add additional clarifications and questions. So something I might have clarified 2 weeks ago might have been a little tweaked later on. So we'll keep you posted and updated on information of that nature. But thank you, everyone.
Nyla, thank you for the update. We appreciate it. Of course, there's a lot of information to consider there. Keeping an eye on some of the comments. More than one are noting the breadth and potential impact of the ETS, and it's no small lift. When you talk about compliance, I agree with that wholeheartedly. For now, I think we just need to take a look at, take those steps, folks, that are appropriate to prepare on your end, if indeed you're an institution that's covered by this. And then we just need to sit and see what happens at the Supreme Court with respect to enforcement. As Nyla mentioned, indications from a majority of the justices that they were skeptical about OSHA's power to enact this particular standard. I guess we have to wait and see. There's been plenty of surprises over the years with this particular court. And this may be another instance where that's the case. Certainly considering that, along with what we're seeing are the unprecedented increased numbers of positive cases across the country. So Nyla, thanks for keeping tabs on this. I'm sure we'll have you back, whether or not it's to talk about a stay or if we need to get down into the nitty-gritty further. So thank you again. Appreciate it. All right. So this is one of the rare times where Adam and I actually get to appear together on a webinar for the Tuesday programs. We are friends and hang out quite a bit outside of work, but rarely have we been together. So I feel lucky, Adam, that we get to do this.
Andy, anytime I can see you, it brings a smile to my day. So thank you for having me.
Yeah, glad to have you.
Yeah, I appreciate it. So good afternoon, everybody. Good to see you. Every now and then, there is a topic or there are topics that we receive so many questions about that we make the decision a separate standalone webinar is required or necessary to help everyone out. So this is one of those situations. When I presented last week about where we are in terms of quarantine rules and COVID pay, the response that we received in terms of questions and interest was overwhelming. So that is why we scheduled the webinar for tomorrow. It is at noon tomorrow. I believe Andy just put the link to register in the chat. So if you have not registered yet and you would like to, please do so. I'm going to give you a quick overview about what we're going to cover. So first of all, last week, when I gave the presentation on where we are with quarantine requirements, the state had not yet put out its most recent revised quarantine recommendations. Those actually came out late Tuesday night after we gave the webinar. So the first thing we're going to do is cover what are the current quarantine requirements for you, whether you are in Onondaga County or in Rensselaer County or in Erie County or in Nassau County. So we're going to cover the gamut of what are the quarantine requirements. We are also going to take a look at how those quarantine requirements impact COVID pay. And when I say COVID pay, I'm specifically referring to the COVID paid leave law that went into effect in March of 2020. So we're going to cover those two topics. One issue that Andy and I have talked about a lot and that we've been receiving quite a few emails regarding is what to do with these self-quarantine attestations. So several counties, including Onondaga County, where we are, has provided these to the general public where an individual can fill out a quarantine or an isolation form if they're exposed or if they're positive. And the question that employers rightfully have is, do we have to pay COVID leave based upon these self-attestation forms? There is no quick and easy answer to that question. I will tell you we're going to cover it in detail tomorrow. So if that's something you're interested in, please make sure to attend. Before I finish up, I just want to say this. If you have a factual scenario that deals with quarantine leave or COVID pay, put it in the Q&A section now. I'm going to review those tonight and tomorrow morning. I will try to get to as many of them as I can. I obviously won't be able to get to all of them, but if you have something specific, put it in the Q&A and I'll take a look and try to deal with it tomorrow. So thank you, Andy, for giving me time to plug that. I look forward to seeing you all tomorrow, and go Bills.
All right, Adam, thanks. Good to have you with us. So yes, as Adam noted, I did push out a link to where you can register for the webinar tomorrow at noon if you haven't already. If you have any problems registering, let us know. We can certainly help there. Adam, we got a number of questions from people asking whether or not the program would be recorded tomorrow. Typically that's our practice. We'll take a look and hopefully that will be feasible. We get a lot of questions too about whether the slides will be available, and yes, they will. We do furnish those with complimentary webinars. And likewise for this program too, we always publish the recordings of these programs on our webinar along with the slides as a general matter. So you'll have access to those. The public has that as well. And typically we send out an email after the program later in the week, providing a link to the recording and to the slides to attendees. If you're not getting that, please check your spam filter or check with your IT staff who may be able to assist there. You should be getting those messages as well. All right, Adam, thank you very much. Appreciate it. We've got a little bit of time left, and I wanted to cover a few Q&As. There were a number of questions on paid sick leave from last week, so I wanted to cover those and just a couple additional questions that folks posed that I thought would be of general interest. Again, I recognize that many of you have very specific, detailed, fact-sensitive questions And what I would do is encourage you to work with your bond attorney or labor counsel or reach out to us so that we can address those specific questions and that we can do so with there being an attorney-client relationship as well. Okay, so last week we had a presentation on the New York State paid sick leave regulations that were finalized, and in particular, some commentary that was included along with those regulations. And the commentary was insightful to say the least. And one question that we've gotten over and over since then and during the webinar is, well, okay, what about this notion of time that is rolled over? In particular, where I am, what I'm going to say is cliff vesting or front end loading paid sick leave every year for employees to use. And we don't, as a matter of policy, pay out that time at the end of the employment relationship. And we can cap usage during the year. So does it really make any sense to have unused time rolled over? My answer, looking at the statute, it was to this point, no. If we don't have to pay out any unused time at separation as a matter of policy, and if we can cap usage up to whether 40 or 56 hours every year, and if we front load that time every year, well, it doesn't make sense that there would be any obligation to carry over time. Now, in the commentary to the proposed rule, the Department of Labor suggested that there may still be an obligation to carry over this time. Again, this is guidance that they issued as part of Q&A. It is not necessarily law. Can be insightful in terms of how the Department of Labor is thinking, and I suppose conceivable that some regulatory body or other tribunal could look to it for insight. To the extent you have concerns about this issue and how your policy was structured with respect to the rollover of time and the capping of any rollovers, I encourage you to contact your favorite bond attorney. You can certainly reach out to me or another attorney to discuss that issue. We got several questions too about whether or not an employer is obligated to pay out any accrued, unused paid sick leave upon separation of employment. The short answer to that question is no. There's no obligation in the statute that any unused paid sick leave time be paid out upon separation. There's an important point here to be made, though, and I should add that notion generally tracks with the use of vacation time and other paid time off under New York law. As long as an employer has a provision in the policy that specifically delineates that any unused vacation time, PTO, shall be forfeited upon separation, that will be given force and effect by New York courts. So you can have a provision that calls for the non-payment of time and the forfeiture of time upon separation for any reason. Because there is no affirmative requirement in the paid sick leave law to pay out any unused time upon termination, and because the law doesn't specifically address that issue, what we recommend is incorporating a forfeiture provision into your paid sick leave policy or the analog that you may be using that specifically calls out that any unused paid sick leave will not be paid out upon separation, if indeed that is your wishes as an employer. Another line of questioning we got dealt with a threshold issue of whether or not employers can use a combined bucket, right? Can we effectively use a general paid time off policy to satisfy our obligations under the paid sick leave law? Again, here, the short answer is yes, but there is some devil in the details here. We can do this, but it's important to keep in mind that the PTO will need to be administered and set up in a manner that complies with the PSL requirements. So when you talk about the accrual rate, the incremental use rate, and you talk about rollover, the terms of your PTO policy will need to adhere to those PSL requirements and ideally incorporate other provisions that are espoused in the actual PSL statute itself. This is an area where I'm going to recommend you work with legal counsel if you have issues, because there are technical matters on this and you're going to want to receive appropriate guidance. Again, another PSL question that we got is, hey, when does this time get loaded? When does it refresh? And again, that's going to be a matter of policy. The statute talks about having a certain amount of time every year. And depending on your size, it could be 40 hours of paid time, it could be 56 hours of paid time. It will just depend on your size. But it's time that's intended to be provided to eligible employees on an annual basis. Now, based on the statute and some of the guidance that the state has put out, that doesn't necessarily have to be on a calendar year basis. It could be on an anniversary year basis, as is commonly practiced by many employers. It could be on a fiscal year basis, but it just has to be some 12-month period. And if it's different from a calendar year, recommend that you have whatever that term being, that annual term being, have that clearly laid out in your policy. Capping usage, I touched on this briefly again when it comes to PSL. Can we cap usage on this? I think this could be one concern where you have an accrual process in place, 1 hour of time earned for every 30 hours used. And so the accruals could in theory exceed the amount that an employee is eligible to use during a year, whether it's 40 or 56 hours. And here the statute is quite clear that an employer can cap usage up to the statutory maximum on a given basis. And again, this is an area where I suggest that you have your policy clearly reflect that cap on how much time an employee can use for PSL purposes during the given year. All right, so hopefully I covered a number of issues on the PSL piece. I think this is another area. We'll monitor the comments and questions. I tried to cover the broad brush issues as best possible. Again, where you have a nitty-gritty issue that is going to be fact dependent, I encourage you to work with your bond attorney and reach out to us. We're certainly happy to help. Another question I got was, we talked about the proposed, or at least on our blog, we've put out information about the proposed New York HERO Act regulations. And those were the regulations that dealt with the formation of the labor management workplace safety committees. Again, that part of the law went into effect November 1st. And I know a number of clients are keeping this particular issue top of mind. What I would say in a nutshell is it certainly adds some nuance in some areas with respect to compliance, and that steps that employers are going to need to take if indeed you have 2 employees, as the guidance states and the regulation states, 2 employees raise their hand and express a desire to create one of these committees. And again, as we interpret the statute, and I believe consistent with the regulations that were promulgated, there's no affirmative obligation for an employer to create this committee on its own. Rather, it's initiated when, again, those 2 employees raise their hand and say, we'd like to form this committee. And then a certain number of procedures will need to ensue from that point. And so I don't think you necessarily need to really get fully briefed on these regulations at this point. Good to be familiar with them. And it's something you're going to want to consult if and when you have employees do raise their hand and seek to establish a committee like this. Just keep in mind there is an exemption under the statute where the particular workplace already has a committee in place that meets or exceeds the standards that are set forth under the HERO Act. And that will be the key issue, right? So if you do have one of these committees in place already, and if you subsequently do have employees raise their hands and express a desire to create such a committee, what you're going to need to do is analyze the committee that you already have in place and compare it with the requirements of the statute and see how well they marry up. This is an area where, again, it's going to require legal analysis and a level of judgment there, and I encourage you to work with legal counsel on that issue. Alrighty, and finally, even though I know we've covered it, I know we had many questions from folks here on the issue of quarantine and isolation and COVID pay. I just wanted to reiterate with anybody, in case you were paying attention to something else, we're going to cover this issue tomorrow at length. Adam Masterilio has prepared a program. It'll be noon. Again, I've put a link to how you can register for this program in the chat function. We encourage you to register. We look forward to seeing you there. And in the meantime, please be well and be safe. Thank you.